Hello everybody, my name is Lanka Ellingham. Along with my colleagues Jinrong Lee and Sarp Oken, we will be discussing the Deepwater Horizon disaster and the ethical and legal issues that surround it.
The Deepwater Horizon disaster is the largest marine oil spill in history. It is an explosion of an oil rig owned by British Petroleum and operated by Transocean. It is a combination of various failures of the oil rig, causing explosion and led to the oil spill. The initial explosion killed 11 workers and injured 17, and the oil spill continued to damage the environment at the Gulf of Mexico and destroying natural habitats. This event has cost BP billions of dollars. Now we look at the cause of the disaster. The oil well owned by BP and Transocean needed a sealing mechanism made with cement. The cement design wasn't strong enough, but the pressure testing result on the oil well was not interpreted correctly by the crew. They believed the sealing was working. Eventually, the sealing failed, along with a couple safety mechanisms leading to the explosion.
Now we will examine some of the ethical issues present in this case. From the Professional Engineers Act of Ontario, it can be seen that four subsections were violated in this particular situation. The first being negligence, the second being failure to make reasonable provisions, the third being the competence in the performance of professional engineering service, and the fourth being the regard to practitioners' duty to public welfare as paramount. Here, we can see that there were 2 points in this case where this problem could have been avoided. First, having the concrete designs be reviewed before implementation, and second, paying more attention to pressure tests before the operation commenced. We can see that the culture at BP, which promoted profit over safety, resulted in negligence for both of these.
So how do these decisions compare? Well, first, the peer review of concrete design allows for a check of errors and the competency of the practitioner, and adds input for provisions that will make the concrete as strong as possible, satisfying the competence and provision subsections. Knowing the crucial points of the pressure test will prevent the practitioner of being negligent, will satisfy the negligence subsection. Implementing a workplace culture of safety prevent this situation from happening, while other stakeholders such as the CEO of BP view profits as paramount instead of safety. If this conflict persists, then the practitioner should go to PEO.
We decided that the only way to solve this problem was a combination of all of our proposed solutions. The first being allowing for the review and test of the cement design, the second being training the personnel and the engineers better, and the third being implementing a culture of safety over profits in the company.
When we look at the legal issues that surround this case, we can see this is a tort law case. First, look at the duty of care that was owed by the defendant BP. So they're expected to maintain a clean environment so that the ecosystem wasn't damaged and animal life is preserved. Furthermore, human and economic activity shouldn't be affected. They're also expected to maintain a safe work environment to preserve worker health and safety. So, was there a breach in duty of care? Well, yes, there was, since the oil explosion and spill has negatively affected the aforementioned communities. We can note that there was no contractual agreement from most of the above parties, but from Donahue versus Stevenson, we know that an agreement does not need to exist if there is harm from failure. When we look at the injuries themselves, they include the injury and death of the marine animals of the environment, damages to the coastal habitats, human neighborhoods leaving their homes due to reduced quality of life, loss of work and lower economic activity, and finally, the death and injury of the workers of the rig. So what are some of the local laws that can be applied to this case? First, the Ontario Water Resources Act can be used to prosecute since the oil spill dramatically reduced the quality of water. Furthermore, a regulation of the Occupational Health and Safety Act for offshore oil and rig operations can be applied since unsafe practices led to injury and death due to priority and profit. Finally, the Environmental Protection Act can be enforced since the dispersal of pollutants destroyed the animal life and the habitats that they belong to. So what were some of the damages that were recovered from the defendant? First, BP was expected to pay $20 billion for the initial loss of employment in the Louisiana area. Another $7.8 billion was made for the victims of the disaster to support their medical issues. Fines will also need to be paid for restoration efforts and research. Finally, some employees face trial for negligence and destruction of evidence.
In conclusion, the Deepwater Horizon disaster is an important example that shows consequences of negligent and incompetent activity. It has caused a very negative impact on the local environment and communities. We as engineers need to improve professionalism to prevent this from happening, and if we fail to do so, we will face legal issues that can incur financial and personal loss. Hopefully, such disaster will never happen again.
Thank you for listening to our presentation, and I hope you learned something about all disasters and the ethical and legal issues that surround them.